International Research Conference of General Sir John Kotelawala Defence University. Now you are here with us in the technical session held under the theme of expanding the horizon of commercial law for national prosperity. This time, the conference is held in a different platform due to the current pandemic situation of the country. Therefore, this session will be conducted in a virtual platform. The session will be chaired by Dr. Kotelawala. Ladies and gentlemen, we have the honor of giving a brief introduction of the chairperson of this session, Dr. Kotelawala. Dr. Kotelawala holds a PhD in law from Brunel University of London and an LLM in International Trade Law from the University of Wales, Cardiff's institution. Whilst practicing in all areas of general commercial litigation, Dr. Varnasurya has worked as an association at Global Solicitors, Wembley in the United Kingdom. He possesses experience in international business and commercial negotiations in countries across the Europe. His expertise is broadly in the areas of corporate and commercial laws with particular emphasis on international trade finance. He is also an attorney at law of the Supreme Court of Sri Lanka with over 18 years experience as a legal counsel. Moreover, he holds and has held a number of visiting academic appointments and has authored several works on commercial and international law. He is intensively involved in international fora and has given presentations and reports on contemporary legal issues and law symposiums held in many countries. Now, I cordially invite Dr. Kotelawala, the chair, to commence the session. Over to you, sir.
Thank you. Hello everyone. Thank you for inviting me for this event, and I'm honored to be here, and especially in front of my sir, Dr. Rodrigo, who taught me contract law when I was at law college. And if we talk about today's session has been named as expanding the horizons of commercial law for national prosperity. I think this is a very contemporary tagline to have a discussion on. Why I'm saying this one? Because we are having this pandemic situation which we have never expected in this type of magnitude. So when we hear the word commercial law, first we need to find out what the commercial law is. First, we have to define the word of commercial. In simple terms, you can say mercantile, you can use many words, but in simple terms, it is business. Commercial is, the meaning of the commercial is business. So then what is a business? Business is an activity or an entity which are aimed at making profit. So whenever you carry out a business, you have to negotiate with other people in the form of having contracts. So when you have to negotiate, always you have your interest to safeguard, and also the person who is subject to the negotiation with you has his own interest as well. That we have now two parties who are trying really hard to get the best out of the business deal. So when you have that situation, what happens is that both parties may try to deviate from the objective of the contract that they have entered. When you had a situation, you need a mechanism to protect, a mechanism to solve the matters in between the parties who have entered into contract if they have a dispute. So nowadays we have this court system. If you have a dispute, you can go to court and get the matter sorted. Alternatively, we have alternative dispute resolutions as well in the form of arbitration, mediation, reconciliation, or negotiation in many ways. Okay? And I heard that we don't use the word alternative dispute resolutions anymore. Instead of alternative, now we use appropriate dispute resolution methods, because these alternative methods are becoming very famous in the commercial world. So now you have two different parties who are trying really hard to get the best out of the business deal. So when you have that dispute, as I told you, you need a mechanism, but for that mechanism to determine whether the mechanism to determine whether to protect the parties' rights, we need a system of law or set of rules. Okay? So this is where, in simple terms, commercial law comes into operation. We have business dispute, and to sort out that dispute, we need set of rules. Right? So therefore, it is very important that we have a strong set of rules to safeguard business interest as well as consumers' interest. In that event, what I am suggesting is that our country is having a very bad time when it comes to economy. We really need our contribution to bring our economy to a good state. So therefore, as lawyers or people who are attached to legal profession or legal field, or maybe you can be an academia as well, we have to make our contribution to the society, especially to bring our national economy to a place where we can be happier. So therefore, I really appreciate the effort made by KDU to discuss this very contemporary topic. And also, when I went through this abstract, I found very interesting topics that they are intending to talk about. So therefore, I'm looking forward to hear from you, all the presenters, and also at the end, to summarize your presentation, I will make final remarks as well. And also, you need to know that you will have only 10 minutes to your presentation, and I kindly request you turn on your video because you have panel here as well. So it will be very. Therefore, please turn on your video when you make presentation, and also be ready to be questions by the panel and also by the audience. And also for me and to help me, I have Mrs. Lihini De Silva as well. She is my reporter. So starting with, I'm going to start this session with a presentation it is a combined effort by Ms. Hasini Ratna Malala and Padmaja Vijaysurya, and it is the title of this presentation is Intellect Eclipse: An Analysis of Unconscious Bias and its Impact on Development of Intellectual Property. Let me introduce the presenters. authors are lecturers in the Faculty of Law, General Sri John Kotelawala Defence University, Ratmalana, and they are attorneys at law and currently reading for their MPhil and PhD in law. Authors hold LLM and LLB honors from the Faculty of Law, University of Colombo, and Ms. Hasini Ratnamala holds an LLM in Human Rights Law from University of Minnesota Law School, USA, and her research areas are human rights law, jurisprudence, international humanitarian law, and then the contributor, Ms. Padmaraja Vijaysurya, holds an LLM in intellectual property law, Faculty of Law, University of Exeter, UK, and her research areas are patent, trademark, and traditional knowledge. So now, may I invite Ms. Hasini Ratnamala to make a presentation. Also, I need to mention that when you make the presentation in the 9th minute, that you will be notified by our lecturer, and so please make sure that you are confined to the given time period. Thank you. Mrs. Ratnamala.
Yes, I'm trying to open the PowerPoint site. Give me 1 minute, please. Can you see the PowerPoint site, the audience?
Yes, we can see.
Yeah, thank you. Good morning, Honorable Chair, distinguished guests, and my colleagues. Our presentation today is Internet Eclipse, an analysis of unconscious bias and its impact on the development of intellectual property law. Content of this presentation is as follows: introduction to the research objectives, followed by research questions, research methodology, discussion, and finally, as usual, recommendations and conclusion. This is an interdisciplinary research. This is a combination of both intellectual property law and feminist legal.
Can I interrupt Ms. Ratnamala for a moment? And you need to share your slides on the MS Teams. We can't see your slides. And also, if you don't mind, can you turn on your camera as well, please?
I will have turned it on.
We can't see slides at the moment.
Okay, let me check. Give me 1 minute, please. Sorry about this.
Now we can see. Thank you.
Can you see the slides, sir?
Yeah, we can see. Thank you.
In my company, it's still logged in. Give me 1 second, please.
Okay, now we can see you as well. Thank you.
sorry, I can't see. Now can you see?
We can see slides.
Okay.
Yeah.
You can see me as well.
Not at the moment.
Can?
Yes, Hasini, we can see you now.
Okay. Let me start with the beginning, so on the introduction. Today our presentation is on intellectual gifts. It is an analysis of unconscious bias and its impact on the development of intellectual property law. Content as follows: introduction to research, research objectives, research questions, methodology, discussion, and final recommendation and conclusion. Introduction to the research. As I previously mentioned, this is an interdisciplinary research. It's a combination of both intellectual property law and feminist legal theory. Feminist legal theory is focuses on guaranteeing equality between men and women in the areas such as employment, family relations, right participation, economic rights, and political participation. On the other hand, intellectual property law is providing legal protection to aesthetic and scientific work by authors. And this research leads to see whether there is historical relationship between these two branches of law based on analytical review on the sub-areas, so subdivisions of IPA such as copyright law, trademarks, and patent law. Let me elaborate on the research objectives and research questions. The main objective of the research is to analyze the historical development of intellectual property law and its contemporary challenges in light of the feminist jurisprudential implications. The secondary objective is to examine the probable links between the areas in intellectual property law, such as copyright law, trademarks, and patents law, and application of relevant theoretical paradigms of feminist legal theory. We drafted research questions accordingly. Whether there is a historic relationship between these two branches of law, and secondly, whether this relationship between two branches of law being indicated in the subsections of intellectual property law, such as copyright, trademark, patent, and litigation process, especially in the litigation process. Let me discuss about the research methodology. Research methodology is based on the legal research methodology. Therefore, it is adhered to doctrinal research, which is purely on library-based secondary data review. Data or literature selected on the purposive sampling, using the purposive sampling methods, focusing on most authority writers in both areas. Let's move to discuss on the areas of this research. Here the IPL is new knowledge and feminist legal theory on the other hand is based on the concept of equality between genders. Let me elaborate on Holbert's views in this regard. Intellectual property scholarship and feminist epistemology have proceeded upon parallel but unconnected tracks. According to feminist legal theory, gender is socially constructed. What is socially constructed? Socially constructed means that something based on societal norms or attitudes on certain things. Societal norms are mainly based on stereotypical attitudes. Therefore, it is indicated that unconscious bias or stereotypes has shaped women's participation in enriching intellectual property law as indicated in the slide. Let's focus on subdivisions of intellectual property law. First, the copyright law. Copyright is the term that is used to describe the areas of intellectual property law that regulate the creation and use of range of cultural goods such as books, songs, films, and computer programs. Social construction of gender copyright law, how it affected. Theoretically speaking, women stand outside or on the periphery of masculine creation. If creative work, either scientific or artistic, is to be protected legally, if we balance view of the work of men. On the other hand, craft labor focuses on labor performed by women, involving care, the labor of hand, brain, and heart. Masculine knowledge is within a capitalist mode of production that is early, dividing subjects from object and law from the law. What men do for recognition, women do for love. That is the attitude. What is the outcome? Result of discrimination in organized law, as indicated before, women's ability in tradable areas were not recognized similarly to that of men. In order to remedy the above, female authors led by feminist movement started printing presses to overcome challenges in the male-dominated printing presses in pre-Second World War era. Concerns of very prominent authors such as Mary Ann Evans. I think you have heard of the name George Eliot, who is the famous book Meal on the Cross. In that era, female authors published under male names. That is one of the experiences faced by female authors. And cooking recipes and knitting patterns will be shared generations to generation from country to country without any copyright protection. It is another indication that let's move to patents and feminist legal theories relationship. Patents, what is patent? It could be defined as a limited monopoly that is granted with return to the disclosure of technical information. Less female lawyers are involved in the litigation process in American intellectual property law. I would like to draw your attention to another empirical case study-based research carried out by Kotelawala. Essays on women and intellectual property law, the challenges faced by female attorneys pursuing careers in intellectual property law. It indicates that less female lawyers are involved in the litigation process in American IP law. For that, the author indicates there is a need of technical qualification of scientific knowledge, equivalent in addition to the bachelor's degree in American legal professional requirements. But we could sort of generalize this. It is common to most of the other countries' legal systems, even without requiring such functional qualifications into thinkability. Let's move to litigation process and intellectual property and the theory of feminist legal theory. Successful legal practice is again influenced by unconscious bias. Here also, we utilized another empirical research led by Dr. Nishara Mendes and the team. It is a quantitative research on undergraduate law students' attitudes on legal profession, and this also established the same research outcome. Internationally, women were allowed to study law and enter the bar relatively after a long time to that of men. Pursuing legal education and a career, especially in the legal practice, were influenced by perception and social norms regarding women, that is the Sri Lankan study. And again, I am citing Kotelawala. They are the trespass into small boys' club of intellectual property litigation, and one of the interviews, Sandra, an attorney, mentioned in her own words. Finally, reaching to the outcome of the research, I would like to draw your attention to conclusions and recommendations. Conclusion is the masculine social construction of knowledge, means that women and men primarily participate in an already determined system, trained by masculinity as the literature suggests. Unconscious bias or stereotypical attitudes and roles of men and women historically played a negative role on women's contribution to IPL and continue to this date. Recommendation: recognizing the glass ceiling effect, the unconscious bias, and the discrimination in IPL in order to obtain full contribution to women's expertise to enrich the sub-areas in IPL, to get the whole picture, the benefit to IPL, thus adopting holistic approach to get better results in IPL. Finally, awareness raising through communication and academic engagement to enrich the areas to women's full participation. Thank you very much. Thanks a lot.
Thank you, Kotelawala. Our next presenter is Ms. S.M. Anuruddhika and G. Seneviratna. This is a combined work by Ms. S.M. Anuruddhika and Ms. G. Seneviratna. Is Ms. Anuruddhika Gayatri Seneviratna, and the title of the presentation is Contracts Formed During Frustration and Post-Merger, an Anti-Crisis Shield for Consumer Protection Against Boilerplate and Limited Liability Process. To talk about the presenter, Ms. Seneviratna is an attorney at law, registered complaint secretary, licensed notary public, and commissioner for orders. She holds double bachelor degrees in law and natural science. Also, master's degree in business administration from University of Western Sydney, and another 2 master law degrees from University of Colombo and Kotelawala Defence University. Her key research interest areas are corporate law, criminal law, and jurisprudence. And may I now invite Ms. Anuruddhika Seneviratna to make the presentation.
Thank you, sir. Can you all hear me?
Yes, we can hear you.
Yes, very good morning to the session chair, panel of judges, and all presenters. Let me share my.
May I interrupt you? Can you share your slides as well? We can't see your slides.
Right. Can you see the presentation, sir?
Not yet.
Is it clear now?
Do you have slides to share?
Yes.
We can't see slides yet.
Is it appearing now?
Not yet, I'm sorry.
Can you see now?
No, unfortunately. I think you have to move to the icon next to the leave button. No, not that one. You can see the leave button. Before that, next to that, you have an icon. Share.
I share the content button. Can you see me now?
No, we can't see.
Yes.
I can see. Can you see now? Can you okay?
Still, I'm sorry, still we can't see. You can see on your right hand, on the right top, leave option. Before next to leave option, you can see with the arrow in the box. In the box.
Yeah.
Yeah. Please try it again. Yeah, click that.
Can you see?
Still no.
Okay. Oh. Ada share picture එක click කරලා ඔකේ appear වෙනවා. අර link එකට මොනවද එන්නේ? Oh.
Hasini, can you hear me? Kotelawala? Can you stop sharing your slides now? Because I think that's the difficulty we have here. Still you are sharing your slides with us. Hasini, can you hear me? Anandya, can you hear me? You have to unmute your microphone. Can you hear me now?
Yes, sir, I can
Okay.
hear you now.
Are you okay to make a presentation without slides? Okay, please go ahead then. Thank you. I'm sorry we can't hear you. You have been muted.
Can you hear me now?
Yeah, we can now.
Oh, sorry for the interruption, sir. Due to technical faults, let me start my presentation. Good morning to the session chair of the panel and all presenters. Presentation of my research topic is contract form during frustration and post-merger and anti-crisis shield for consumer protection against water trade and limited liability clauses. And the outline of my presentation carries introduction, significance, research problem, objectives, methodology, findings, and what we can learn from comparative jurisdiction, conclusions, and references. As you all know, all production and consumptions are outcome of various contracts between producers, consumers, and intermediaries. Due to the rapid economic post-merger frustration, bargaining power and the freedom of contract drastically altered and curtailed for consumers compared to the superior position of intermediaries. Therefore, in such conditions provides ideal opportunities for such intermediaries to include various extension, boilerplate and limited liability clauses for contracts in general, as well as specially for standard form consumer contracts. The same condition gives the perfect opportunity for legislators and lawmakers to examine the real robustness and effectiveness of prevailing recalibrate the existing doctrine or to develop new laws. Therefore, when it comes to an impediment, sellers able to deploy unfair commercial practices by including various exemptions, limited liability and indemnity clauses just for their undue enrichment and to cater their self-interest. Also, they can include abusive boilerplate clauses and standard form clauses to standard form contracts to exploit consumer rights and freedom in various forms, such as price gouging, pressurizing the buyer to take or pay for the goods, forcing buyer to accept the substitute goods according to the seller's choice, whereas they can make degradations, they can refuse or restrict buyer examination of goods before accepting them, they can include non-refundable payment terms, they can adopt unreasonable time frame for deliveries, or they can prohibit or restrict consumer order cancellation. Also, they can provide incomplete and misleading information and advertising on goods. Also, they can refuse or restrict certain modes of payment for buyers, such as cash or credit card. Therefore, in a normal contractual context, when an impediment occurs, not to strike a balance between the rights and liabilities of contractual parties and to avoid the breach of contract, two fundamental principles are used. The first is contract law-based principle of force majeure. Second is the common law principle of frustration. And when we examine the existing research literature and case law, we can clearly evidence the application of these two principles for contract form before an impediment, as well as it is evident for contract form after an impediment. But application of these two principles for contract form during an impediment is not clear. Therefore, it is not settled. So, there is a substantive and procedural legal gap when it comes to application of those two principles for contract form during an impediment. So, my research problem is, does the application of common law principle of frustration and contract law principle of force majeure are legally valid for contract form during an impediment? And what are the legal complications and implications of such application, especially on consumers at large? So the objectives of this research are first to examine the legal validity of applying contract law principle of force majeure and common law principle of frustration to contract form during an impediment, explore the legal implication of application of above principle on consumer contract during impediment, and compare and contrast the legal applicability of those two principles to contract form during an impediment, especially in Sri Lanka, comparative to Polish and Singaporean laws, in order to make recommendations for domestic legal reforms. So this is basically a qualitative research based on comparative and critical analysis approach based on domestic law, Polish and Singaporean laws. Primary data gathered through national and comparative legislation, case laws, directives and regulations made by respective jurisdictional statutory authorities, as well as those further strengthened with peer-reviewed law journals, books and contributions and reviews given by professional experts of contract and commercial law areas. When we turn to the findings of the study, we can identify two major differences between these two principles. Force majeure is an event or a situation which is unforeseeable at the time of formation of a contract. Therefore, it is unavoidable and impossible to overcome by the parties to a contract. Also, under English law, there is no blanket definition for a force majeure. Rather, it was left for parties to define exactly what they consider to be a force majeure for a particular contract. Based on that, either one of both parties to a contract is entitled to excuse or suspend the performance of a whole or part of the contract upon occurrence of a force majeure. Also, they will not become liable for failure to perform their obligation as articulated by the contract upon a force majeure. Therefore, 10% Comparing the principle of force merger, principle of frustration applicable, where performance of a contract becomes impossible, illegal or fundamentally or radically different than it was intended at the time of formation of a contract due to non-holding of the contractual partner. Based on the case law, we can identify three major types of cases on frustration, where the agreed performance of the contract became impossible, where mutually agreed purpose of the contract became impossible to achieve, and where there is a significant change in mutually agreed state of affairs. Therefore, upon the successful proof of frustration, it will automatically discharge all the obligation of contractual parties immediately, terminating the contract without any further steps. Therefore, upon the total failure of the performance of a contract due to frustration, court most likely be ordered to return money if there's any money has been already paid. Also, if the court be part of the contract now to a separate contract and there's a frustration, it is referred to as a partial frustration. And if we consider the applicability of these two principles for contract form during an impediment, we can see those two principles become not applicable due to four major reasons. Because impediment exists at the time of the formation of the contract. Therefore, impediment has been reasonably foreseen or experienced by the contractual parties at the forming of the contract. As well as contractual parties able to formulate their contractual terms inter alia reasonable to suit and cater special contractual conditions considering available options and possibilities to mitigate the impediment and its consequences.
You have 1 minute left.
Contractual context become the normal contractual context. When it comes to domestic application, there are three major laws: Sale of Goods Ordinance, Consumer Contracts Act, Consumer Terms Authority Act, which provides no guidance for this kind of a situation. Therefore, it is basically required to become unpredictable in such situations. Also, domestic law does not stipulate in proceeding order how to apply these two principles. So, what we can learn from other jurisdictions is we can enact effective statutes like frustrated contract application. Therefore, we can assign a priority order of applying the principle. We can freeze the contract until the impediment is under control. We can insert post-mortem clauses retrospectively for pre-endemic contract. We can interpret the boilerplate clauses in their own wording based on considering the difficulties encountered by the contractual parties under the light of law. And we can impose various monetary fines for certain infringements. And if there is any failure to comply repeatedly, we can impose like a percentage of traders preceding an annual turnover on such infringement. Also, we can enforce some sort of like quasi-consumer protection measures for small-scale businesses like sole proprietors and partnerships. Also, we can get involved with global consumer protecting bodies such as International Consumer Protection Enforcement Network to help give the consumer some sort of protection. So, what we can learn from this study is it reveals that there is a gap in the contract law reference to contract form during an impediment. The two principles what we can apply for pre and post contract is not applicable in such conditions. So, therefore, present contract law is yet to settle how to address right remedies and relief of contractual parties during an impediment. Therefore, in order to combat and mitigate such exploitation and abuse of consumers, we need to have some sort of effective domestic legal framework. And these are my references. Thank you.
Thank you, Ms. Senegatna. And I made a mistake. I effectiveness of piercing corporate way under Sri Lankan law, a comparative analysis with UK. The presenter is Major R.M.R.K.K. Ratnayaka. Major Ratnayaka, he is the head of the Department of Law, Faculty of Law, General Sir John Kotelawala Defence University, Sri Lanka. She is an attorney at law. She holds an LLB from the Faculty of Law, University of Colombo, and LLM in International Business and Commercial Law from Ealing Rosewood, University of West London. She has obtained Masters in Human Resource Management from University of Colombo. Additionally, she is an attorney at law at the Supreme Court of Sri Lanka and a Law Republic Commissioner for Oaths and Registered Company Secretary. And now we invite Major Ratna to make the presentation. Major, can you turn on your can you turn on your camera, please?
Yes, I have just turn on the camera.
Turn on, we can't see you.
Really? Okay.
a technical difficulty. We will ask Major and also the next presenter, Jayasekar, to make their presentation a bit later. And in the meantime, may I invite Ms. Shanali Dias. Are you available online?
Hello, can you hear me?
Yes, Shanali. Okay. Are you? Okay, I can see you. Okay. Our next presenter is Ms. Shanali C. Dias, and her presentation is titled as Copyright Protection of Application Program Interfaces Analysis of Sri Lankan Position. And Ms. Dias is a junior counsel in the chambers of Dr. Harsha Kaplar, President Counsel. She holds an LLB from University of Berwick, an LLM in International Business Law from the National University of Singapore, an MBA from the University of Berwick. And may I now invite Ms. Dias to make a presentation.
Thank you very much, Honorable Chair. Can you see my slides?
Yeah, we can see.
Okay. Good morning, Honorable Chair, distinguished guests, ladies and gentlemen. Software has now become a necessity in our daily lives. In fact, if I had to be with you in person right now, I would have ordered it and tracked my way on the app. My research today focuses on exactly that: application program interfaces, or APIs. APIs permit the communication and facilitation of data exchanges between software. Using the example of the Uber app, an API is what the developers of Uber have utilized to obtain location data from Google Maps when using their app, without having to understand the Google Maps algorithm. In the absence of APIs, developers would have to write new code each time they wanted their software to interact with another software and make them interoperable. As APIs do not generate data themselves, they are often considered as conduits or information pathways, thereby being deemed purely functional. It has become fairly settled law overseas that the functional aspect do not attract copyright. Also, it was until Oracle America filed a case against Google for the use of Oracle's Java API without authorization in its Android operating system, and cast doubt on the treatment of APIs under copyright law. Without delving into the policy arguments surrounding the API copyright debate set out in my paper, I will now explore the question of copyright protection of APIs under Sri Lankan law. Under the Sri Lankan Intellectual Property Act No. 26 of 2003, original computer programs are specifically protected. Now, what constitutes originality is not precisely settled law in Sri Lanka. There are two common thresholds for establishing originality in the UK and the US. The FICE standard in the US, wherein a meaningful level of creativity is required for a work to attract copyright protection, and the UK's approach, which includes the recognition of works which do not have creative expression but have been compiled with intellectual effort, often referred to as the spread of the brow doctrine. In Sri Lanka, the 2018 case of Director Department of Fisheries, Lloyd Fernando, His Lordship Justice Priyanka Jawad held that since the production of the work in question involved skill, choice of language and style, composition, and intellectual effort, the work was original and therefore attracted copyright. This wording does not preclude the sweat of the brow doctrine. Thus, there is a high likelihood of APIs being deemed original in terms of the Act defines a computer program as a set of instructions expressed in words, codes, schemes, or in any other form, which is capable, when incorporated in media that the computer can read, of causing a computer to perform or achieve a particular task or result. As APIs are a set of instructions on how to communicate with software, they can, for the purposes of the Act, be deemed to cause a computer to achieve a particular task or result by transferring information. Thus, prima facie, APIs are protected under law. There are several points where APIs can be argued not the term computer is also defined under Section 5 of the Intellectual Property Act to mean an electronic or similar device having information processing capabilities. A strict construction of this definition may exclude copyright protection, as there may be implied restriction of the applicability of the Act to scenarios involving physical devices with information processing capabilities. Further, in terms of Section 8A of the Intellectual Property Act, copyright protection will not be extended to any idea, procedure, system, method of operation, concept, principle, discovery, or mere data, even if expressed, described, explained, illustrated, or embodied in a work. One said provision has yet to receive judicial consideration in Sri Lanka. APIs have the potential to fall within the wording, method of operation, in the aforementioned section due to their utilitarian nature. US courts have held that the menu command hierarchy of software is uncopyrightable because, without it, users would be unable to access or control the software's functional capabilities. Therefore, in theory, APIs can be deemed to fall within the category of a method of operation, as they set out a method to allow interoperability between software systems. Additionally, Section 8A may allow for instances where the expression of an idea might not be subject to copyright. The wording may open the door for the entry of an equivalent of the merger doctrine, a judicial construct of US copyright law. This recognizes that the idea and expression have merged to the extent that they are indivisible and prevents courts from deeming a work as attracting copyright protection if there is only one or limited means of expressing the said works. However, whether Sri Lankan courts would accept such an interpretation or reject the doctrine like their counterparts in the UK is yet to be seen. Thus, it is difficult to assess whether APIs attract copyright protection in the first place. In the event of a finding of copyright, the applicability of values should also be considered. Apart from the non-exhaustive examples set out in Section 11.1, Section 11.2 sets out 4 considerations, namely the purpose and character of the use, the nature of the copyrighted work, amount and substantiality of the portion used, and the effect of the use upon the potential market for or the value of the copyrighted work. It is interesting to note that these factors reflect the same 4 factors in the US Copyright Act, and the outcome of the Google and Oracle saga could potentially be influential in future interpretations of this section. On a first reading of Section 11.2, it can be argued that since APIs are used solely to achieve interoperability, there is no inherent commercial value in copying the API itself. However, if under judicial consideration, the assessment of commercial use includes the ancillary benefits that arise from the use of the API, such as the ability to interoperate software due to the API, and thereby improving the commercial viability of the new software, it is likely to fail this link. The utilitarian nature of APIs may support finding of fair use in terms of Section 11.2b, as APIs involve more than a series of creative choices. Further, as per Section 11.2c, the degree of copying is relevant. If the API is copied verbatim, it is unlikely to amount to fair use. However, if only features are copied and improved upon, there is a likelihood of coming to a finding of fair use. Finally, assessing the market value and the effect of use for the potential market or value of the copyright API in terms of Section 11.2b is heavily contextual. For example, if a modified API is copied, there would be a market available for it. Thus, development is heavily dependent upon context and the circumstances involved, and there is no clear indication as to how it will be treated judicially. It is evident that the wording of the Intellectual Property Act and existing case law on intellectual property do not give rise to a clear stance on copyright on APIs. Technological innovation is likely to be disrupted if the software industry is not certain as to where it stands. In the event APIs constitute copyrightable works, players in the software industry may find that they are liable for inadvertent copying, or they may find themselves reinventing the wheel by constantly having to create new APIs to avoid copyright infringement. Further, the impact of such ambiguity may also be extended to businesses outside of the software industry that are relying on APIs as a cornerstone for strategic expansion, as it opens them up to claims of copyright infringement. The circumstances are such that it behooves the legislature to consider and provide guidelines as to how APIs should be treated under the law. In the interim, one of the options available to the software industry would be to focus on the development of APIs that involve less creative choices, and thereby reducing the chances of attracting copyright protection. Failure to provide clarification would result in the structure of the software industry and all other industries that are looking to APIs for strategic purposes to be left mired in uncertainty and, in a worst-case scenario, potentially subject to long drawn-out legal battles.
You have 1 minute more.
Potentially subject to long drawn-out legal battles, such as that of the proceedings between Oracle and Google. Thank you.
Thank you, Ms. Dias. Okay, now we can switch on to a very conventional way of presentation. It's very very familiar method we have used to. And so may I invite Dr. Major Ratnayakar to make a presentation.
Good morning, everyone. I'm Major Ratnayakar. I'm Major Ratnayakar from Faculty of Law. So today my presentation is regarding the effectiveness of the using of corporate care under Sri Lankan law, a comparative analysis with the UK law. This is the overview of my presentation, as you can see in the screen. So, principle of corporate wealth. Before that, I'll start like this. modern form of cooperation have been emerged in 20th century, but thousands years ago, when Romans were conquering the world, that corporations were built up. The separate legal personality, the fundamental concept of a separate legal personality have been built when a company has been formed. It says that company has a separate legal personality from its members. So these are the distinguishing features of the principle of separate legal personality. So it can conduct its business, own property, enters into legally binding contracts, and also company incurred into its own debts, and it can sue and be sued in its own name and be liable to pay taxes. So the veil of incorporation, actually this veil of incorporation is the metaphorical veil. We cannot see it or touch it, but it's between the company and the shareholder. What it does is that it separates the company from its shareholders, and shareholders can take this corporate veil as a shield to protect, to evade from the liabilities of the company. In the eyes of law, these shareholders were separated from the company. So the Solomon was the famous landmark case which that concept was built. And in this company, that if I have give you a short brief introduction about this Solomon versus Solomon Company Limited case, Mr. R. Solomon was a boat manufacturer. So on the request of his family members, he has built a limited liability company, but within 1 year they have been bankrupt. So then the company liquidator claimed that Mr. R. Solomon has to be, he's the one who is liable for all the debts of the company. The lower courts that they accepted the claim of the liquidator, but when it goes to the House of Lords, as you can see in the screen, Lord McNaughton said, company can be considered as a different personality from its members and is not an agent of its members or a trustee for them. So they have accepted that separate legal personality and the veil of incorporation is there. So Mr. Solomon is not responsible for all the debts and liabilities of the company. So after much of the Solomon vs. Solomon Company Limited case, in these cases, they have accepted the classical, judicial precedent of the Solomon vs. Solomon Company Limited decision, and they have given the same decision which has been given on the Solomon vs. Solomon. And corporate veil piercing. So there are two instances of judicial veil piercing and statutory veil piercing and the corporate veil piercing. So in here, the judiciary and legislation has they are lifting or piercing the corporate veil, and they are looking who's behind this corporate veil. So when we consider about the English law, there are three phases of judicial veil piercing. The first one is the classical veil piercing, and it also says considered as the early experimentation type. This was from the date that Solomon was decided and to 1945. So the classical application which has been made at the Solomon vs. Solomon was applied on this period, and the head of the doctrine period. This is the golden era of piercing of corporate veil. Actually, the Lord Denning has done commendable job in this time, and in the case of Littlewood's May Lord Stone's case, that he has condemned the Solomon vs. Solomon Company Limited decision because it was blindly adhering to the Solomon case, versus Solomon case decision by the court. And back to basis, it's from 1972 present. So when it is necessary to do justice, so the court used to pierce the corporate veil. So there are common grounds of veil piercing: fraud and misrepresentation, and agency principle, which is like a principal company and the agent company. So principal company is also should responsible for the acts of agency company in a tort cases and proof of companies and sham of facade. It means that when a company has been built to evade the legal responsibilities. So under these instances, judiciary try to pierce the corporate veil. So statutory veil piercing. So you can see in the screen. In Companies Act 1985, United Kingdom, Section 70, criminal liability has been imposed for the untrue statements of the prospectus of the company, as well as Companies Act 2006, Section 349, the rights of independent assessor, right to information has been ensured. Likewise, Company Directors Disqualification Act 1986. Likewise, these are the statutory provisions that engage with the piercing of corporate veil. When we consider the Sri Lankan context on corporate veil piercing, we can see very few cases in Sri Lankan law. So, the Vishwalingam versus Lianagale, Upatta versus DFCC Bank, and especially Golden Key case. In this case, Supreme Court has ordered that directors of the company to pay for the depositors by selling their own property. So in these cases, very few cases in our history that try to pierce the corporate veil and try to catch up the perpetrators of these corporate frauds. So when we consider the statutory provisions of Sri Lanka Companies Act 97 of 2007, you can see that there are several sections regarding piercing of corporate veil, especially its duty to keep up record of accounts in a company, and when duty of directors in insolvency, then when they know that their company is going to bankrupt, they have to make a claim, they have to inform that for court, and they have to start the winding up process, as well as operation when a minor shareholder has been, when they have the unjust, they have treated badly, they can go for court for claim, like by fraudulent trading. Even company has bankrupt, they are conducting their businesses to evade the legal responsibilities and to cheat and their creditors. Likewise, these are the statutory provisions we can see in Companies Act of 7 of 2007 in piercing of corporate veil. So, when my conclusion and recommendation, actually, companies represent most every day in our life. So they are the backbone of the economies. But they always try to do frauds, taking that corporate veil as a shield to protect. So in here, the pierce the corporate veil to identify the actors, hide behind and impose liability. That's the most important thing. Especially as you know that fraud case, central bank. Likewise, corporate giants always try to hide behind this corporate veil. And of course, judiciary play a vital role in statutory provisions in corporate veil piercing. Now, as you can see that very few cases in our history regarding piercing of corporate veil. So judiciary has to play a role to pierce the corporate veil and try to find who are behind this, behind all these frauds. And from that safeguard the minority shareholder. The minority shareholders, the holders are the one who suffer the most when corporate fraud has been occurred. So we have to safeguard the minority shareholder rights, and of course finally the public convenience and the education. This is a must because people don't know about these things. So we have to convince the public to switch the red light for the perpetrators. Thank you very much.
Thank you, Major Ratnaka. Now we have our final presenter. The presentation is about legal implication application of COVID-19, force majeure, and contractual obligation in international sale of goods. This is a combined work of Y3 Vijayaratna and B.M.K. Jayasekara. Today, the presenter is Ms. B.M.K. Jayasekara, and she is the head of department and senior lecturer in Faculty of Law, General Surgeon, Kotelawala University of Sri Lanka. She is having Bachelor of Laws and Master of Laws with specialization in international law. Additionally, she is an attorney at the Supreme Court of Sri Lanka and the Notary Public Commissioner for Oaths and registered company secretary. She has been teaching public international law, private international law, and interpretation of statutes in undergraduate and postgraduate courses. She has published articles in books, chapters, prominent law journals, along with attending and speaking at law conferences. She was an editor of the KDU International Law Journal, KDU Conference, Abstract and Proceedings, and South Asian Law Review. We are now invite Mrs. V.K.M. Jayasekara to make a presentation.
Good morning, everyone. Today I am going to discuss legal implications of COVID-19, force majeure, and contractual obligations in international sale of goods. This was written by myself, V.K.M. Jayasekara, and my colleague, Y.K. Vijayaratna. COVID-19 was initially identified in December 2019 in Wuhan, China. Thereafter, to contain the virus, countries have resorted to various measures to restrict movement nationally and internationally through national lockdowns, nationwide curfews, closure of international borders, and suspension of international travel. The unfavorable impact of COVID-19 on the wide spectrum of daily activities, particularly on national and cross-border trade, is tremendous. These unprecedented circumstances raise questions about the liability of parties to international commercial contracts for failure to meet their contractual obligations due to COVID-19. In this situation, the force majeure clause in contracts and relevant laws could be useful to protect the parties. If the contract relates to the international trade of goods, the CISG, the United Nations Convention on Contract for the international sale of goods, may apply. In view of this, the current research examines the application of force majeure to grant relief for non-performance of contractual obligations due to COVID-19, where the CISG governs a contract. Then I am going to discuss the research methodology. Doctrinal research methodology was followed to reveal the primary and secondary sources. It took qualitative approach. Now let's move to discuss what is force majeure rule. It is an internationally recognized principle that contracts must be entirely performed by both parties. However, if parties to contract are unable to fulfill their contractual obligations due to the occurrence of an event beyond their reasonable control, the law provides relief through the operation of force majeure. The term force majeure refers to a superior force event such as acts of gods or acts of war. Generally, most international commercial contracts include a force majeure clause. Now I am going to discuss the discussion, and I am going to move to discuss the analysis part, especially the effect of force majeure in contracts under CISG during COVID-19 crisis. First, we have to look at the sphere of application of CISG. When we see the sphere of application of CISG with the close of international borders and implementation of different social distancing methods, contractual obligations such as provisions of goods or services internationally are largely affected in
current circumstances. In view of this research critically analyzed the function of force majeure during COVID-19 crisis to relieve those who are parties to contract that come within the purview of the CIST. It applies to the sale of goods when both parties to the contract of sale have their places of business in different states that are both contracting state unless the parties have excluded its application under the Article 6 of the CIST. However, even if one or both parties do not have their place of business in the contracting state, the CIST may apply when the rules of private international law leads to the application of the law of the contracting states, subject to the limitation of Article 95 of the Convention. Unless the contract especially excludes the application of the CIST or the parties otherwise so indicate, the CIST can automatically apply the transactions of a party with foreign buyers or suppliers of raw materials, commodities or manufactured goods. The second point which I am going to mention, the force majeure under the CIST. The term of force majeure is not explicitly used in the CIST, however, it is widely acknowledged under Article 79 of the CIST. Accordingly, the impediment beyond the parties' control is considered the basis for the force majeure. Also, pursuant to Article 79 of the CIST, if the party in breach does not comply with the requirement of giving a notice to the innocent party regarding the impediment and its effect on the inability to perform within the reasonable time after the non-performing party knew or ought to have known of the impediment, that party will be liable to pay damages resulting from non-recipient of such notice. The effect of Article 79 of the CIST is providing a defense to the non-performing party of a contract, a defense against an action for damages and not to terminate the contract. The CIST imposes liability on the party relying on the breach of contract aspect. Article 77 of the CIST dictates that the parties shall take reasonable measures to mitigate damages caused by the other party. In the event of non-compliance, the party in breach will be entitled to claim a reduction in damages. Further, under Article 79(3) of the CIST, temporary impediments will only temporarily cause the obligo for the period for which the impediments exist. This is not a permanent period. And the third point which I want to explain is COVID-19 pandemic and Article 79 of the CIST. In view of the early analysis and Article 79(1) of the CIST, COVID-19 pandemic is likely to be considered a force majeure event. Clearly, the impediment caused by COVID-19 is beyond the reasonable control of parties. It should also be relatively easy on most cases to prove the causal link between non-performance and COVID-19, that non-performance is due to an impediment as a result of COVID-19. Whether the parties could have avoided or overcome the consequences of COVID-19 would have to be decided by ascertaining the circumstances of each case. In the event of the parties to contract that are subject to CIST wish to derogate from Article 79 of the Convention, they can choose to include a force majeure or hardship clause in the contract and agree upon more flexible or broader terms and consequences in view of the force majeure event. Notably, contractual guarantees also may constrain a degree to which parties can rely on this article. Now I am going to discuss the findings and conclusion. In light of the analysis of Article 79 of CIST, force majeure can simply operate to excuse non-performance as a result of COVID-19, provided that the elements of the Article are duly fulfilled. Given the precedent, Article 79, however, it is unlikely to provide relief to non-performing parties of contracts that were entered there after COVID-19 was officially declared a global pandemic by the WHO. The implication of COVID-19 in international contracts under CISG would have to be decided on the case-by-case basis. To receive relief under CISG for the impediment created by COVID-19, parties are advised to adhere to the crucial requirements such as tendering reasonable notice of non-performance and take requisite measures to mitigate the resulting losses of the pandemic. And these are the findings and conclusions of our presentation. Thank you so much.
Thank you, Mr. Chairsecker. Now we move on to question sessions. Presenters are required to answer questions from the audience. If you have questions, we can raise now. But before that, let me start questioning. I have a little question about the presentation made by Miss Anuruddhika Seneviratne. And can you hear me, Anuruddhika? Okay. And your title, the presentation title is Contract Formed During Frustration and Force Majeure and Anti-Crisis Shield for Consumer Protection Against Boilerplate Limited Liability Clause. So the title says Contract Formed During Frustration. So my question is, so if you know that the event is going to be frustrated, no one will enter into a contract. If they enter, then that will be a mistake. So you have it. Switch on the microphone, please.
Can you hear me, sir, now?
Yeah, we can hear you.
The answer to the question that you raised, sir, when it comes to tendering, there are, even though we presume no contracts are formed during such a period, there are very vital contracts formed during such conditions, such as contracts for food, pharmaceuticals, or hygiene product manufacturing, likewise. So, my research is basically focused on that particular period. In a frustration of force majeure, there are essential contracts are to be formed. How are we going to deal with such contracts?
Okay. And I have another question. You have selected a Polish jurisdiction. So I can understand selecting Singaporean jurisdiction. You have reason for to take a Polish jurisdiction?
Yes, sir. Because when I studied on this research topic, it was extremely difficult for me to find some sort of comparative jurisdiction where I can find some sort of very active measures taken by certain countries. So I was only able to trace Singapore and Polish are the most active lawmakers when it comes to this kind of a situation. And my recommendations are based on whatever they have actually adopted and tested method. So they are the one who actually identify priority order on applying the principle of force majeure or when to apply frustration, as well as other recommendations. So those recommendations are well tested on those two jurisdictions.
Thank you. Anyone has any questions? Yes, sir. Dr. Rodrigo has a question.
Yes.
Wait, sir. Mr. Microphone. Question is Ms. Ratnamalala.
Ms. Ratnamalala, your paper is on an analysis of the unconscious bias and its impact on the development of intellectual property law. Now, in particular, you have develop your paper in the light of the feminist jurisprudential interpretation. The way in which you have presented made your presentation, I got the impression that you think that the female members of our society are still being discriminated against, and that the male dominant society. But I feel that if you take constitutional provisions dealing with equality, in our constitution, Article 12, Sub-Article 1 deals with equality, the principle of equality, and in the same article, Article 12, Sub-Article 4, takes, I think, remedial measures in order to remedy the effects of past discrimination on female members of our society, if any. And even if you think about the historical development, now there was a time at which marriage was considered as an incapacity for as far as contractual capacity is concerned. Now, for example, prior to the enactment of the Human Rights and Inheritance Provisions, marriage created a community of property under which the properties of both spouses fell into common pool, and the husband became the controller of the common pool. But thereafter, the matrimonial rights and inheritance ordinance of 1877, and after that, the 1877 ordinance abolished the concept of community of property. And in 1924, the Married Women's Property Ordinance gave full contractual capacity to women. So now in our country, for example, I think there are sufficient measures in place. Remedial action has been taken. So therefore, I think you would have improved your work by referring to such remedial action as well. The paramount law, the Constitution, itself has taken. Otherwise, it makes no sense. On the one hand, Article 12(1) speaks about equality. And Article 12, Sub-Article 4, gives us a category into which, even disabled persons and children also fall. Not that women are disabled, nor are they children, but the legislature or the architects of the Constitution have taken them into consideration. Thank you very much. Apart from that, your work is commendable. It's a very good work. I really enjoy it. Thank you. Thank you.
Thank you very much for the excellent comments, sir. I want to emphasize on certain points. What we have discussed is equality between men and women, the substantive equality. What you have indicated was this de facto equality. Right? When it comes to substantive equality, it is the combination between de facto equality and de jure equality. De jure equality was your points of indication. The constitutional provisions and other acts and those ordinances and amendments. But when it comes to unconscious bias, so that is the meaning of my topic, the unconscious bias. Right? Unconscious bias in men, the stereotypical attitudes on men and women, it is intangible. When it comes to de jure provisions, it is tangible. It is sort of our research outcome was trying to find a tangible outcome in intangible subject matter. Now, we discussed about the historical areas of discrimination. That is, of course, as you discussed, lots of achievements are there in de jure wise. But when it comes to de facto in the sense, the implementation. For example, Now, as you mentioned, in Sri Lankan jurisdiction, we have achieved de facto, de jure equality, but this research is on de facto equality, in which, for example, like since you have indicated some points of data. For example, 2019 World Bank, Central Bank report indicates it's like 37% of female labor force in Sri Lanka. 70% is of men. And at the same time, when it comes to intellectual property law contribution, now, as you have seen, or any of you have sought, there is no practical representative, de jure barrier to legal practice in intellectual property law or in any sense. But when it comes to de facto, the glass ceiling effect or the unconscious bias, those glass ceiling effect is when stereotypical attitudes towards women in practice, men in practice, so it is common to all the areas. Particularly, that's why I indicated certain areas from American jurisprudence where technology or scientific qualifications also needed to get into patent or practice, where women are less participating as attorneys. At the same time, the empirical research in Sri Lanka, which we have done led by Dr. Vishal back in 2008, in that also female and male students attributes on women into practicing law. So, as you mentioned, so as you very correctly mentioned about the de jure aspects of this area, it's highly acceptable, but when it comes to de facto, the intangible outcome, as you mentioned, there is no barrier getting into practice or getting into anything in Sri Lanka for women. But when it comes to the facto glass ceiling effect, there is an issue on equality between men and women. I mean, the de facto, if you need to achieve substantive equality, it should be a combination of both de facto equality as well as the de jure equality. That is my point. I hope you got it.
Thank you, Mr. Kotelawala. And we have one more question from Dr. Sampath Mujeva.
My question is directed to Ms. Sonali Dias as regard to the very innovative area of research that you have presented today. My question is that you cited jurisprudence from the European Court of Justice in the SAS case. And as to my understanding, the European perspective take cognizance of the very high threshold of copyright protection. And in that case, if I am not mistaken, the European Court stated that the high threshold of copyrightability would not warrant protection under copyright law, but it would be elsewhere, perhaps in the industrial design protection or any other type of IP right. So my question is now, in Sri Lanka, as you all know, our copyright jurisprudence is based on very much into the common law world, where the threshold for originality is less, as you have rightly looked at the Pice case. And in your estimation, do you think that in the Honorable Justice Priyantha Jayawardana's decision that you cited can be further improved by viewing through the lens of this European jurisprudence?
You have to unmute your microphone.
Sorry. Thank you very much for asking it. The thing about the SAS Institute case, it was heavily within the context of Article 1.2 of the Council Directive. So, whether that would be applicable in our legislative context is something that really needs to be looked. For the further into. As I said, sorry, can you hear me?
Yeah, we can hear you.
As I said, in Justice Jayawardana's case, Director Department of Fisheries and C. Lloyd Fernando, it's not really clear as to what sort of threshold has been established now. It could involve creativity as well, but it doesn't necessarily preclude the spread of the broad doctrine. In context of API, some of them, there are two arguments as to how API should be classified, because they are purely functional. You could say that there are very few choices. You have to go down a particular path to get to this destination when you're creating an API. And on the other hand, you could say there are actually several choices that you can make. But one choice will always be better. There will be a more efficient way. So when you consider that, it's really hard to tell whether an API would, if say we go by the creativity threshold, would meet that. But I believe that under Justice Jayawardana's current test that he applied, APIs would be considered original in terms of Section 6(1)(a) of the Intellectual Property. I hope I've answered your question.
Thank you, Shanali. We have this time constraint, and therefore we have to sum up this session. Making the final remarks, I would like to thank all the presenters for making your presentations, and it was very interesting to hear what you have found in your research. And especially when you talk about the presentation made about post-major frustration and Sri Lanka post-meaningful inconvenience, right? So because with this current situation, we all wonder what will happen in the contract that we have made, especially leasing agreements, loan agreements, and other type of financial arrangements. So when you talk about these things, so there was a discussion about moratoriums, and also there was murder as well in this regard. So in this particular scenario, when the contracts are getting frustrated, the best way to get out from that problem, for me, what I understand, to have a clause to review the contract again, rather than applying frustration principles or any other principles. It's better that if we can have a possibility to review the contract according to the requirement. And so moving on, when I consider about your presentation, I have a very humble request to make. So I supervise master students' reservations, and so when I have master students in Sri Lanka, they always talk about Sri Lankan law. However, there is a huge vacuum in the literature regarding commercial law. We have some books, when you check the content of those books, the content is about the act, for example, the Company Act or maybe the Property Act, but there is nothing, there is no substance to take from those books. So therefore, I kindly request everyone, the research findings and what we have done, develop them to a stage where we can participate as a group, especially make them very contemporary and find new case law, and we have very